All right, good morning. Today is June 6th, and this is the Land Use and Sustainability Committee meeting that got postponed last week to this lovely Monday morning. Hopefully everyone had a great weekend and was able to stay dry. We're going to do a little bit of housekeeping here. We've got a number of items that are deferred. Tom, keep me honest. The first one is item number 1. Is that going to be deferred? I see a verbal report here. Is that a deferral?
Well, I'm working from the published agenda, Mr. Chair, and if you want, I could just go through those real quick and announce those so that if anybody's following in the public, they'll be following from the same agenda.
Okay, go ahead.
So item 1, and again, this is from the published agenda. Item 1, which is an amendment, a proposed amendment to the automatic stay provisions in section 118.9 pertaining to CUPs. That's been withdrawn by the sponsor, so that won't be heard today. Under discussion items number 7, 8, and 9, and 10, and 11, and 12, and 13, and 14 have all been deferred to the July 7th meeting. Item 15, which is permitting live entertainment to promote arts and culture, and item 16, which is an amendment to Chapter 122 of the LDRs regarding workforce and affordable housing. Those will be discussed by land use today. And then finally, item number 17, regarding composting, that has also been deferred to the July 7th meeting. And then finally, a previous item that was scheduled to be considered today regarding criminal penalties for demolition by neglect, that has also been withdrawn by the sponsor.
And what item number was that? Oh, that was number 18. Okay.
Yep.
Great. Okay. So then, Tom, that means items 2, 3, 4, 5, 6, and 15, 16?
That's correct.
Okay, great. All right. I don't have any requests for taking things out of order, I believe. Is that correct?
Nope.
Okay. Then why don't we start with item number 2? This is my item, an update on our LDR and resiliency code.
Okay.
Tom, are you doing this one?
Yep, I'll go ahead and kick this off, Mr. Chair. This particular item was a dual referral to both the Land Use and Sustainability Committee and the Planning Board. And we have our consultants here who are going to provide a brief presentation. We had wanted this to be heard by the Land Use Committee first, but we had to postpone this meeting from last Wednesday, so we went ahead and had our first Planning Board Community Workshop last Friday, June 3rd, where our consultant team provided a much more comprehensive and detailed presentation. We have another Planning Board Community Workshop scheduled for June 17th, and we expect the full document, at least in working draft form, to be released prior to that date. Moving forward, we expect the Planning Board to be able to consider the final document for transmittal at their July meeting, and we would be bringing this document to the City Commission for consideration at first and second reading in September and October. As indicated in the memo, and our consultant team will go through this in more detail, the proposal is twofold. One, it is a much needed update of our current land development regulations, which were last updated comprehensively in 1989. So a lot of the changes that are proposed are clarifications and updates. The more significant portion of the legislation, however, is the resiliency code portion, which is going to incorporate more comprehensively much needed updates to address long-term resiliency and sustainability. As both the committee members are aware, over the last 5 or 6 years, we've done a number of piecemeal ordinances to address resiliency and sustainability. This is a much more comprehensive approach to this. It's also important to note that there are more significant amendments that we envision that we would like to pursue in earnest after the adoption of the code in the fall, so that we can focus on things like TDRs and how to incentivize living shorelines individually as we move into early 2023, particularly since some of these may require voter approval. So with that, I'll go ahead and turn it over to Jose Gelabert, and then I believe our consultants from Toronto are on Zoom, correct?
They said they were connected. and panelists.
also. So, they are. Okay. Good morning. It's wonderful to be here. I almost would call this, at this phase, the motherhood portion of the code, namely that there almost should be nothing that people should be against in what we're doing with the update. Tom already described part of our mission, which was that we're taking a code that is 30 years old, a code that has been adapted, modified to the extent that right now it almost takes a zoning attorney to take you through it because it is so complicated. It's complicated not only for the folks in the city to interpret it, but frankly, perhaps more important for the community. Even for single-family houses, which are actually probably the most common application that the city of Miami Beach has, it's a complicated document to understand. So, as Tom said, our charge was to do two things. One was to bring this code to the 21st century and to consider the fact that, you know, Miami Beach, as we all saw last weekend, it really is like ground zero for seawater rise and issues with water. So some of those things we now want to be part of the code. The second part is really a simplification, a clarification, going through the code and seeing all the possible conflicts and contradictions there were within the existing code and to remove them. We're trying to make the code more user-friendly so that a property owner, whether it's a developer, but more important if it's a single-family homeowner, they can look at the code and they can understand it. And we're replacing a lot of words with simple to understand charts that my partners will take you through. And we also have a pretty exciting interactive system with a company called Gridix, in which the code will be really an interactive tool that you can get to at home, look up your site, look up what you can do and all that. A lot, you know, again, very, very user-friendly. As Tom said, there are other aspirational ideas with the code that some of which require voter approval. So we will go into that at the end of our presentation, sort of future possible tasks. But I'd like to start, should have started with that, introducing myself and my team. My name is Jose Helibert Navia. I am with the firm of Perkins & Will. We have been in Miami now for 25 years, and I have been practicing in Miami Beach for 40. So I'm, as they said with Hair Club for Men, I'm a user as well. I have been trying to navigate this code for a long, long time. With me, with Perkins & Will, are my partners that you will meet virtually, Paul Kulig and Anna Iannucci. They are in our Toronto office, and they have been dealing not with seawater rise in Toronto, but there's actually a very important analogy, and the problem in Toronto is actually sunlight, not water. However, they do have a city which is in the midst of tremendous development. So they have been going through similar exercises on how do you update a code while the city is in the midst of major development, as well as projects all around the country. Our partners in this project is Florida-based planning firm Plusurbia, And Plusurbia is a specialist in form-based codes. They have worked on a number of similar projects. And with me today is Maria Benfeld, and Maria has been pouring through the code, and she will take you through it as well. Also in our team is Ana Helibert Sanchez, the former planning director of the city of Miami. Again, some of the process, eventually we want this code to be approved by the state. So a lot of lessons learned of issues that came up before the code became a reality have been very helpful. And speaking of not having legal challenges, also in our team we have Nancy Stroud. Nancy's an attorney with a specialization in similar codes. She's worked on a number of similar projects, and she's already working with Nick and other people in the city to make sure that the language in the code is absolutely consistent, and that hopefully we have, once it gets approved, we don't have any legal challenges as well. And she was able to accomplish this in the city of Miami. So hopefully she'll be able to do the same thing in the city of Miami Beach. So at this point, I'd like to introduce my partner in Toronto, Paul Kulig. We can go through the first slides, Anna. Again, we've gone through all of this. So again, these were our very, very basic, simple goals and our mantra going through this whole process. We want to make this a living document. We don't want, again, to have the situation we have now, that we're dealing with a 30-year-old car that the warranty has been over for quite a long time. We
Can I
want
just ask you, in the interest of time, just if we can speed it up a little bit?
Okay.
We're well familiar with the narrative and the situation, if we can kind of get to the meat of it.
Okay, so
Maybe I could just ask a little. Let me just ask a couple of questions that maybe we can move this along. Have you done public hearings on the proposed changes?
we're starting them now.
Okay.
But what we did do at the beginning of the process is we held a number of public meetings to get input
Okay.
as to the current code and what folks wanted in this new code. And we had about 10 of those meetings.
Okay, to get input, and then you went to work and prepared some draft changes, right?
Exactly.
Okay,
Exactly.
and have these proposed changes been presented to the public for comment?
Our first public meeting is next Friday, the 17th.
Okay, so Tom, I don't know what the timeline is on this, but I need those public meetings to happen. I think we need to get input. I'm not going to be prepared to, go into all the details and so forth. What is the timeline on this?
So from a timing standpoint, we envision having we did get some comments and feedback from the planning board members and the public last Friday. We expect to get a lot more on June 17th, and then there's going to be one more planning board meeting on July 26th, and that we envision to be the actual transmittal meeting. And then it will come to the commission for first and second reading in September and October. To the extent that you would like to discuss this again at your July 7th meeting to get a summary of comments to date, and certainly if you'd like to discuss it at your September meeting, you could certainly do that. That's why this was referred to this committee, so we could have that ongoing discussion.
So is there anything in this version that's going to require voter approval?
No.
Okay. Well, I think in the interest of time, Chair, what I'd like, if you're amenable to it, is to we can get private briefings on all the details, but I really want this presented to the public, all the folks that do the work in the city, and let them comment on it, and that will better inform me. And as long as we're not rushed in that it has to be put on the referendum or anything, then I think that's I'd like to do that if that's okay with you.
Yeah, I think, you said a couple things that I was interested in learning more about, making the code more user-friendly. And I think, in order to do that, we, to your point, need to actually talk to the users. In my mind, I don't know how you're going to have these public hearings, but, there's the sort of single-family home market and then, the multifamily condo market. But, when you go to the single-family home neighborhoods, you reach out to all their HOAs and you have those meetings, where they live, and have very user-friendly guides as to what we're trying to accomplish, and then get user feedback. I don't want this to be a top-down approach, if we can avoid it. There are best practices that we want to adopt, share those with homeowners. Let's hear what they have to say about, whether those things are onerous or acceptable or not, so that we can take those into our own deliberations. I think, we're talking about resiliency in a single-family home. We're talking about things like elevation, talking about things like driveway runoffs, retention of water on property, trees, gutters, all of those things. And I think if we put it together in a very user-friendly handbook and say, this is kind of where we're at, and this is where we want to take you, and then just take that feedback. That'll be a helpful guide. I'm not telling you how to do your job, but I think if we do something like that, I think we come out with a good result. And then, I think for developers who build multifamily dwellings and condos, I think you get together with them as well, to see what we're not doing today that we need to be doing, and that they need to be doing in future developments.
Right. And does this cover the work that the city's doing, or is this just basically the code for single-family homes? And
No. This is the entire code.
So if the city were to do a project, then this would be applicable to that as well, right?
Yeah. There would only be one code.
And we did.
Yeah, I understand that, but I don't know if the changes you're proposing are just related to single-family homes.
Oh,
And
no, I'm sorry. It's to every single project in the city.
Okay, so for example, a water project that would put piping down the middle of a street, would it cover that?
No, that's more public works.
Yeah, that was my question.
I'm sorry. I thought when you meant the city is if the city was doing a municipal building or if the city was doing the parking structure.
Okay.
We're covering things underground.
Got it.
I'm sorry, above ground.
Okay. So one of the things you said in your conversation there you said this is going to have to be approved by the state. And did I misunderstand you? So what does that mean?
The final version of the code has to be also approved by the state.
Well, do they approve it, or just it has to be in alignment with state law?
It has to be in alignment with the plans that have been submitted to the state before.
But we're not going to take.
It has to be consistent with the comprehensive plan, and so if there are any changes to the LDRs that would require a separate comprehensive plan amendment, we would have to send that comprehensive plan amendment to the state. The actual LDRs don't require state approval, only approval from our city commission. But if there are any modifications to the LDRs that require corresponding comprehensive plan amendments, those comprehensive plan amendments would go to the state for review.
And do we know the version that you have now, the working version, does it include
I don't
anything?
believe that we have any changes that I think would require a comprehensive plan amendment. However, if there are changes that do come about, we could certainly submit a comprehensive plan, either text amendment or regular amendment during the amendment cycle.
Okay. And you said we could bring this back at our meeting in June?
July 7th and September 13th.
September 13th is when you want to get that back to the commission in September, right?
Yeah, our intention would be to bring it to the commission for first reading on September 14th. So even though it's the day before, it would still give you time to provide some additional input. The other thing I wanted to mention, and Jose touched on this briefly, is that this has been about an 18-month process. And one of the first things that we did for actually the first 6 to 8 months was we engaged in focus group meetings. And we wanted these to be more individualized. Homeowners groups, developers, attorneys, a number of different affected stakeholders. And we did that before they started their scenario planning and actual drafting, so we had their input first. What we envision now with the public hearing process is people being able to see the finished product. From a substantive standpoint, it's not going to be a radical change. In other words, the development regulations for each district are remaining largely the same. Use regulations are remaining largely the same. However, the resiliency components, we believe, are going to be significantly enhanced. But I think most importantly, the updates and clarifications and simplification is what you're going to find to be the most appreciable difference.
Okay, so what public hearings can take place before the July? What date did you say? July 7th?
Yeah, the next Land Use Committee meeting is July 7th, and we have a Planning Board community workshop scheduled for June 17th. And then after the June 17th Planning Board meeting, the July 7th Land Use Committee meeting, there will be another Planning Board meeting on July 26th. And then we've got a Land Use Committee meeting scheduled for September 13th.
Okay. So I will move that we keep it in committee right now, if that's okay with you, Chair.
Yeah, I mean, we're not against a time crunch. This is not
No,
going
not
to
at all. This was
voters.
primarily meant to be an introduction to
Yep.
you. So
Yep.
even the presentation that they had was very abbreviated, but if you'd rather just move on, we could certainly discuss this in more detail at
I
your
would
July
like,
meeting.
and then what I'd like is just for someone to schedule a time with me, and then I can just go through the details in
Sure.
that way, rather
We
than.
were planning on doing individual briefings with each of the commissioners, so we can certainly reach out to your office to do that.
Perfect.
Okay, let's keep it that way. Okay.
All right, so I'll show this by acclamation as being continued to the July 7th meeting.
Great. Thanks, guys. Thanks for
Thank
your
you
time.
so much.
Thank you so much.
Thank you.
Thanks. Let's move on to see some folks here. Are you all here for item 5? 3. Okay, let's do item 3 then. Rooftop additions in the CD3 district.
I'm going to
Yeah,
kick
tee it
this
up
off.
for us.
All right, Mr. Chair, this particular referral was also a dual referral to the Planning Board, and it's scheduled to be considered by the Planning Board at their June 21st meeting. Currently, in local historic districts, there is a limit of a one-story rooftop addition. And even though that one-story rooftop addition is subject to Historic Preservation Board approval, no one can propose anything higher than that, even if they're well below their maximum height limitation. The proposal herein, which was put forward by the Gale Hotel on 17th between Jefferson Avenue and, James Avenue and Collins Avenue, would allow for multi-story rooftop additions not to exceed the maximum height limit of the district. They also could not exceed the current FAR set forth in the district. The administration is supportive of this proposal because it would still require Historic Preservation Board approval, which would ensure that any multi-story rooftop addition would be sensitively scaled and massed. And so we would recommend that the Land Use Committee also endorse the item.
So it's not going to increase far, and it's still going to be within the height, right?
That's correct.
And it's your recommendation that we move it, right?
That's correct.
Okay, so I'm going to move the item as presented.
Yeah, and I'll second it. The reason I sponsored it is because I didn't see any harm in this. This was a reasonable request of a really nice property, and you know they're trying to invest in the area. We want to see more investment in that area. I had no problems with this.
Exactly.
Someone online? Okay.
Yes, we have one speaker, Mitch Novick.
Okay. Morning, Mitch.
Hi, good morning, everybody. I was here in the early 90s when a single-story addition along Ocean Drive was increased to 2 stories, a 2-story addition. And there's a number of buildings, Casa Grande, the Pelican, Cafe Milano, they have 2-story additions. And the preservation community was bothered by this, and eventually a prohibition on rooftop additions were put in place because of the negative impact of 2-story additions along Ocean Drive. They're incompatible with the context of historic buildings, and they should just be limited to a 1-story addition, in my opinion. Thank you.
Thanks, Mitch.
Mr. Chairman, we have one more caller, Daniel Seraldo.
Morning, Daniel.
Hi, everyone. Hi, commissioners. Good morning. Sorry I can't be there. There's a mural that we're working on saving. But on this particular project, the only question I had was for Tom, whether any rooftop addition would be required to meet the setback guidelines of the Historic Preservation Board, because I think that would be important that any of those standards would not be relaxed. So just a question. Thank you.
And I can answer that. The setback requirements would remain the same. Residential and hotel uses have to follow the setbacks that are required under the RM3 district. Additionally, it's probably most important to point out that under the appropriateness criteria, the Historic Preservation Board has the latitude to require greater or additional setbacks depending upon the design of the rooftop addition and the location of the rooftop addition.
All right, well, item's been moved and seconded, so we'll move on. Okay, nobody else? Let's do item number 4. Commissioner Richardson, this is your item, parking garage heights on Terminal Island. You want to tee it up?
Thank you. I will turn to the administration. Tom, can you walk us through this?
Sure. This is a proposal that would, it's a very small amendment to the parking garage section of the code. Currently, main use parking garages are limited to the height within the zoning district in which they are located, and on Terminal Island that would be 40 feet. However, parking garages in the CD3 district are allowed to go up to 75 feet, and the proposal herein would allow for main use parking garages within the I-1 district only on Terminal Island to go up to 75 feet in height. The reason that this is being requested by the proposer, who was Fisher Island, is that they would like to increase the number of parking spaces that are available in their existing garage, which is close to 40 feet in height. And their rationale is that the cars are already coming onto Terminal Island, but they're getting onto a ferry and parking on Fisher Island. What this would do is it would allow those cars to, instead of getting on the ferry, park in the garage, and then the employees could walk down to the ferry and take a shuttle bus. So our transportation department has looked at their initial evaluations prepared by Fisher Island's traffic consultant and concluded that it does appear that the traffic would be limited to just that, and we are not expecting any negative impacts on the roadway network or on that intersection. So as such, strictly from a code standpoint, this is something that we would be comfortable having move forward. This was also a dual referral and is currently scheduled to be considered by the Planning Board at their June 21st meeting.
Can we hear from the rep for Fisher Island? When's that going to be heard, Tom, in planning?
It's scheduled to be heard by the Planning Board on June 21st, and if transmitted by the Planning Board, it would be considered by the City Commission the next day on June 22nd.
Good morning. Neeson Kasdan, Ackerman LLP, representing Fisher Island Community Association. Tom actually gave a very thorough and concise description of the reason for this. It's called Terminal Island because it's a marine terminal. And one of the things that the Fisher Island Community Association would like to do is do things to reduce the number of ferry trips and the backup of cars at the ferry lines and the cars also that go on the island. So instead of that happening, they would expand the garage, and the garage would accommodate cars that would otherwise have to go to Fisher Island and use the ferry terminal. So that's really the reason for it, and I think it's all not only positive for the island, but positive for traffic on the MacArthur.
Can I ask a couple? So you and I have discussed that we the city need some additional parking in the area as well, and I know we're not going to make it a part of the ordinance, but have you talked to your client about that? Because we need a new facility there, but it's not going to happen, a fleet management facility, but that's not going to happen overnight, and we have a problem, and we need to rent some parking. Is that something you guys were going to consider?
Yes, Commissioner, FICA is very willing to sit and discuss this with the city and consider some relief or allocation for the city in terms of spaces on a temporary or even perhaps longer basis. Can't speak as to the exact number, but they're more than willing to have those discussions.
Okay. So I'm going to move the item today. I'm very supportive of this, but I would like to start those conversations because my support of this is really tied to taking care of another problem there, because there are going to be some people that are not supportive of this height increase. And so I'm supportive of it. I think it fits in with the community there. But I'd like to be able to fix a couple of problems at the same time. I'll fix the problem of not having to take as many cars over to Fisher Island, and also fix the issue that the city has with parking there as well. So let's have that conversation.
We will definitely commence that ASAP.
Thank you, sir.
We've one caller online. Caller number 1.
Hello.
Good morning.
Hello.
Hi, good morning. My name is Matthew Galtanoff, and I'm actually one of those folks who have a concern with the height increase that's proposed for this particular garage. So just a few years ago, 40 feet was the maximum height allowed for buildings on Fisher Island, and that was increased to 75 for the proposed office tower, which was billed as being less intensive. In this particular situation, this is the gateway to our island. This is how you get to South Beach via the MacArthur Causeway, and there are concerns that if you build more parking, you're going to induce demand and bring more traffic onto there, which of course is a large concern. I also want to remind folks that just a few years ago, in fact, just 1 year ago, the capacity for the ferry system was doubled. There's a whole extra ferry terminal that was built, and they've increased from 3 to 6, I believe, the number of ferries. So there certainly is a lot of capacity to cross. And the new intersection that was constructed at Terminal Island and Bridge Road is now troublesome. In fact, many times it's the pinch point coming and going from South Beach on the MacArthur Causeway. So one concern, main concern that I had is that on the agenda item, there was a 2-page traffic study. And a lot of other traffic studies, including for the increase in the garage size for the office project, is nearly 100 pages long. So I think that perhaps there needs to be more study done to this and not just a 2-page summary saying that there won't be any impact, because there is an impact. Since the ferry was doubled and the extra slip was added and the whole entire interchange reconfigured, there are significant traffic problems. So not just for drivers, but there's also 15,000 people a day that ride over on bus. So we have to take everyone into account here, look at this from a holistic viewpoint. And I urge the members of this committee to not pass this today. Because again, more study, more investigation needs to be done and look at the real impact that this will have as one of the gateways to South Beach. Again, my name is Matthew Galtanoff, and I'm speaking as a resident of the South Beach neighborhood. Thank you.
May I respond to that, Mr. Chair? Yeah, because I want to just put the correct facts on the record and on the table. Number one, there's no increase in use that drives demand. Fisher Island itself is virtually completely built out. And so this is only to accommodate cars that otherwise would have to go on the ferry to the island. And the traffic report that you received indicates there may be benefits to the very situation Mr. Galtanoff was talking about. Because right now, if the cars have to go on the island, they have to line up, and that can back almost sometimes into the MacArthur Causeway itself. And then when they disgorge from the ferry, there's a rush of cars. This will likely promote a more even dispersed traffic flow from the garage instead of everyone having to get on the ferry and get off the ferry. It also will probably likely result in less ferry traffic. It's a busy shipping channel. The Coast Guard is there as well. So this is a safety issue from that perspective as well.
No, I appreciate the comment, and I would anticipate you're going to have a less ferry traffic because you can put a lot more people on a ferry than you can cars. And so if you have less ferry, you have less petrol and fumes in the air, so it's better for the environment. So I think this makes total sense, and so I've moved the item.
Yeah, I second it.
Thank
Thanks. Okay.
So, Tom, do we need to do anything else with this in committee, or?
Nope, you've concluded the item. You'll next see it again at first reading on June 22nd.
At the full commission?
Correct.
Thank you. So we're sending it to planning with a recommendation, right?
Correct.
Perfect. Thank you.
Great. Okay. Next item is item number 5. This is an important and fun one. Tom, are you going to tee this up? This is a reform of automatic stay provisions.
Sure, and I can, I'll go ahead and give a summary. Nick may have something to add as well. A few months ago, the sponsor of this legislation asked the administration and the city attorney's office to take a look at our current stay provisions and our overall appeal process comprehensively. As the committee may be aware, whenever an appeal is filed of a decision of the Historic Preservation Board or the Design Review Board, it triggers an automatic stay throughout the entire appeal process, not just the appeal before the commissioner or the special master, but if a third party takes the appeal to second and third tier review, which can sometimes take years, that stay remains in effect. So planning and the city attorney's office took a good look at not just that provision, but other provisions of the ordinance with regard to appeals in order to make it much more efficient while still preserving appeal rights for people. And so we have a number of proposed changes regarding timeframes for rehearing, regarding specific timeframes for appeals when they must be heard at oral argument before either the City Commission on DRB items or the Historic Preservation Board, as well as the ability in certain limited circumstances for a property owner to move forward with obtaining a building permit and starting construction, even if an appeal is filed to circuit court or appellate court. We believe that comprehensively our version of the ordinance is important because the reform needs to happen comprehensively. The one area that we have recommended a modification that we think could probably use some fine-tuning is the requirement for the posting of a bond. I've discussed this with Nick, I've discussed this with Eric, and in fact, it might actually be more problematic for the city to manage a very large surety or performance bond, particularly when you have a larger project that is very expensive to construct. But by and large, I think other than that version of the code, other than that section, we think that our version of the ordinance achieves what is being desired in order to reform the automatic stay provision and allow those applications that seek to move forward after an appeal has been concluded at first tier review, which would either be the City Commission or the Historic Preservation Board, would allow, in limited circumstances, the ability for that applicant to move forward if they believe that at their risk that it's not likely that the third party would be able to prevail at second or third tier review. And so we've recommended that the version of the ordinance that's contained within the land use memo be approved. This was a dual referral, so this will be discussed for transmittal purposes by the Planning Board on June 21st, and we anticipate this coming before the Commission for first reading on June 22nd. Nick, anything to add or clarify?
Tom, I think you covered everything. The only thing I would add is that we'd also like the Commission to include briefing deadlines so that appeals get to the City Commission and the Special Magistrate sooner. We think it's in everyone's interest to resolve these sooner.
And do you have a recommendation on what that would be, 90, 120 days?
So what we've included in the draft is an answer brief within 30 days, the initial petitioner's reply within 15 days of that, and then have hold the oral argument within either 90 or 120 days. So for appeals from the DRB, those are heard by the City Commission. Appeals from the HPB are heard by the Special Magistrate.
Do you want to go?
Yeah. Okay. Tom, originally, it's my understanding when this came to the sponsor, it was a shorter proposal, if you will. So, and I think, Mr. Larkin, maybe your firm worked on that. Can you talk about, I guess, the shorter version versus this, I guess, more comprehensive that the city has drafted?
Right, so we have a PowerPoint presentation, but I think sometimes it's better if I just speak. So our original version of the legislation basically just said the automatic stay is there now, but it should terminate upon the conclusion of the city's internal appellate process. You know, we put on there like 4 months. The city had a shorter time period of 2 months. So what we're really saying is there is a right to an appeal, but it's not an unfettered right. The Bulgari Hotel just went through something that took a year to conclude. So that's obscene. So what we're saying with our legislation...
Did that get concluded? I didn't know that.
It got concluded. The special master ruled in favor of the Bulgari Hotel. Now the objectors have a right to appeal to the Circuit Court Appellate Division, and underneath current code provisions, the stay would remain in place.
Right. Okay.
So
I'll get to that. Okay, good.
Right.
When did that happen? I wasn't aware of that.
May 20.
Oh, so it's recent.
25th.
Okay, good. Okay. Oh, okay.
So the way the legislation, Nick just passed out to you all legislation, there's basically 3 component parts. The automatic stay would be lifted after 120 days. So that's 4 months. The second component part basically says from the moment the objector files the appeal, they have 90 days to prosecute the appeal. They have 90 days to get to an oral argument before the special master. And then the special master has 1 more month to the 120-day mark to file his opinion. Within that, what Nick asked us to include was the briefing schedule, which is all there. It's all set out, and it makes sense to me. It was a good idea from Nick. So while there are other changes that are in staff's version of the legislation that are well-intentioned, it makes the ordinance much broader. Ours is much more narrow. Ours, again, there's 3 points. The first is that after 120 days, the automatic stay is lifted. And this is no prejudice to the objectors. They can go to the state court and file a motion to stay and let a trial court judge rule upon that. They can seek an injunction to the issuance of the building permit. The other 2 points are that we don't support any type of bond imposition, and then we don't support reinserting the automatic stay when it comes closer to us seeking a CO. Once the automatic stay is gone, it should be gone. The building permit should issue. We should be able to seek our CO. If the objectors want to fight it on the merits without it being automatic before a trial court judge by the state, that's on them. But our legislation is very simple, commissioners. We respectfully request that you would recommend our more slimmer version to the planning board on June 21st and back to you all on June 22nd for first reading.
So, Tom, the slimmer version, is there anything in the city's more comprehensive that's in conflict with the slimmer version, or is it just that there's additional stuff? So are we comfortable, is the city comfortable with the slimmer version that's before us, but you've got other things you'd like to have considered as well?
So the city's draft version is broader because it does address what we think are reforms needed with regard to the rehearing process, the notice for appeals to the special magistrate and the city commission on DRB items. There are 2 areas of conflict that Mr. Larkin identified. One was the performance bond requirement, which we agree in thinking about it. That's probably not a good idea. And then the issue with the CO. There are some other areas of conflict that he didn't mention. One is that on our version, the only entities that would be able to avail themselves of being able to move forward with a building permit and starting construction are appeals that were not filed by the city or the applicant. And that's important because that's an important safety measure. Under their version of the ordinance, an applicant could file an appeal of, say, a denial of an historic building, and then if that appeal is denied by the special magistrate, under this, after 120 days, they could go and pull a demo permit. And so that's what we're trying to avoid from a safety standpoint in ours.
So you're saying that if the city were to object to something, that you still wouldn't have, we would have to go through the same process.
Correct.
And go to court versus that. So.
We're okay having the automatic stay, excuse me, if it's a city appeal or if we appeal it. This is just really meant to prevent extortion.
No, I understand, and I'm totally supportive because I've only been here 2 years in the city, and I have been very surprised by some of the stuff that goes on here, including the Seagull, which took a year, I think, and it's not over yet.
No.
So it's troubling. Tom, is there anything that would be problematic about doing this in 2 steps? I get that you guys want to do some other things. I kind of like the simpler version because I think it could move faster. And with the change that's just been presented, could we do it in 2 steps?
I mean, it's really up to the committee as to what it wants to recommend, and then ultimately the city commission. If the city commission wants to move forward with a more narrow approach proposed by Mr. Larkin, they could certainly do that. In terms of our recommendation, I wouldn't be prepared to recommend formally on theirs because I've literally just looked at it, and I wouldn't want to give you a recommendation on the fly. But if it's something that you want the planning board to consider, we can certainly bring it to the planning board, and then we could give you a better idea of what our recommendation is before first reading.
Eric wants to go ahead, Eric.
Yeah, I just want to bring everyone's attention to the removal of the CO provision. Actually takes a lot of leverage out of the city's hands if this appeal process proceeds, because it is a coin toss, so to speak. Once the CO is issued, I don't know that there's going to be a way to revoke that CO if someone does succeed in the appeal process. So just put that on your radar as part of the decision making.
But just remember, commissioners, that the way it should be in every other jurisdiction is that objectors can go to the state court and they can try to enjoin the issuance of the CO through an injunction process, or they can ask for a stay of it. So they are not left without remedies. They certainly have remedies they can pursue, as they should. It shouldn't be the local government seeking to reimpose a stay. It should really just come from the state court system and the state court trial judge.
Can I ask a question? Yeah, so I agree with that. The CO is going to come at the end, and with a big project, which is oftentimes where we see these particular projects, we're talking about 3 or 4 years. It seems like there's plenty of time for someone to go to court and to get a stay by a judge. So the one thing that I am concerned about is on if the city has an objection, but you guys are saying that you're willing to work with, you can take that change, right?
If the city is an appellant, so be it. Then the automatic stay would stay in.
Mr. Chair, may I make a couple of comments? Of course, I agree with everything that Michael Larkin has said. A couple of points I'd like to bring out. The slimmer version was something that was presented to the city about a month ago. What has been added has been the appeal deadline provisions that Nick had requested. And that was the original proposal. We also have to understand 2 things that are fundamental. Number one, the biggest problem that we have, all the other items that the city wanted to address are worthy of addressing. But the overwhelming problem is the effect of the stay itself. That's 95% of the problem. The other things we can deal with, but as long as that stay happens, that is the extortion that Michael's talking about. And so we felt that this was the simplest, cleanest way to deal with that issue. The other thing we have to remember as well is, and my colleagues here may testify about their experience as well in other jurisdictions which don't have these automatic stay provisions. And remember, the proposed ordinance that you have, the slimmed down version that you have been presented, says it's when if it's a DRB decision, it goes to the city commission. If it's HPB, it goes to the special master. That means not only will that have been approved by the city's boards, but then affirmed by either you, the city commission, or the special master. At that point, to have a stay makes no sense. And finally, and I understand Tom agrees with this, generally in circuit court actions, it is the party who is appealing who has to post the bond, because you prevailed by getting the lower body to agree with you. And so the damages that will be inflicted are on the party that's subject to the appeal, not the appellant. That's who should be posting bonds. Thank you.
Right. So the timeliness issue, has that been included in this slimmer
Yes, it
version?
has. And the briefing schedule has also been included. And we've been working with Nick. He's reviewed our version too, and I think he would tell you that we've included what he wanted, along those lines. For the record, Carter McDowell, I represent BHI, which is the owner of the Seagull and the developer of the Bulgari. And yes, we've been held up, even in the administrative process. It took a year to get a final order because of the activities of the opponent. We're still in court on three different jurisdictions, so we are not at the end. On the CO issue, two thoughts. One, I hate to put a target in front of the opponent that says, if you can keep them tied up for this period of time, they can't move forward. It's just, you give them a target, they'll try to meet that target. So I don't know that it needs to go, and we would prefer it not to be in the ordinance. But I would also point out, if we get to the end where we're seeking a CO and the court issue is still pending, particularly if it is something that involves a code issue, we will only be able to get a TCO because they won't be able to issue a final CO if there's still a pending challenge. If there are no code issues and it's just, details, if you will, nitpicky details, then I think they could issue the final CO. But being able to get a TCO is incredibly important, because without being able to get at least a TCO, I can't get a bank to finance the project. They will never finance it. So that's a really important issue. I'm not saying that you will get to the end that you will issue a final CO, because that will have to be addressed on a specific project with a specific challenge at the time. But being able to get a TCO, which means you can actually generate revenue, subject to maybe having to make some further modifications, is incredibly important to the property owner and to the process being able to move forward. So we're not saying that unilaterally we can get whatever we want, because we can't. You guys are still in charge of that. But not putting an automatic stay and reimposing it is very important to the development process. We appreciate your time. This is, in my view, one of the best cleanup actions that you can do to help the city's process move on. And I might add, it helps both the developer and the property owner, but it also helps the city administration. Having these things tied up for years makes no sense at all. It just gums up the works. So thank you for your consideration. We hope you'll make that change, and we support it wholeheartedly.
Is there anything in this version that would lock up the city's hands in terms of the CO and force a CO to be issued when the city's not ready to do that?
No, and I would tell you, the city's not going to issue this building permit without a hold harmless agreement. Yeah. We know that. We accept that. The hold harmless agreement itself will say that we don't get vested rights. It's going to give you the authority to hold it if necessary, and if it's not appropriate to issue a TCO even, it will give you the authority to do that. We can't unilaterally take that authority away from the governing body simply by getting a building permit.
Tom, if we move this today, this is going to the planning board, is that?
Correct. It would go to the planning board on June 21st, and then would come to you for first reading on June 22nd.
At the full commission.
At the full commission, correct.
So I want to move this slimmer version with the change that we discussed to allow, if the city is an appellant, then the stay would continue. Do you have any problem making that change, Nick?
No.
So that's what I'd like to, and then I'd also like to request the administration bring a second item that would include the other things you'd like to do. So we can do this in two steps. That's the way that I would like to do it, and that's what I would like to move today.
Did you want to speak?
No, sir.
Huh? Come on up.
Go ahead.
You're about to have a win, so I'm
but
not.
I just thought I could provide some valuable perspective. Alex Wickoff, I'm a resident of Miami Beach. We also have the privilege of developing in a lot of different areas, places with a very strong architectural and very discerning zoning processes. That includes places all throughout Florida, like Palm Beach and Coral Gables, places in Los Angeles that, similar to Miami Beach, with municipalities like Santa Monica and West Hollywood, you could argue may even have a tougher standard than Miami Beach, and then all places like New York City. We've never seen this in one other place. Why? Because it encourages corruption, because there's no standard on the automatic stay. You have to go through the very rigorous standards and the amazing boards we've instituted, the Historic Preservation Board and the Design Review Board. And invariably, every project to go through those boards requires 5/7 vote. It's an incredibly high standard, and what this does is, even on top of that, which doesn't exist in any other city, not in Florida, not in any other major city we can even think of, that on top of that, it gives you 120 days to prove your case with either the city commission in the case of the DRB or with the special magistrate in the case of the HPB. So you're already adding a standard that would put this well above any other place, but there has to be a cutoff, or else all it does is encourage meritless litigation to hold up projects that are great for the city that have gone and got approved 5/7 vote and then survived the 120-day process from the city commission or the special magistrate. So for us, it's just a fairness principle. If you've achieved those really, really, really high standards, and I'm sure you all have seen, right, the level of project you need to get through either the HPB, the DRB, now also survive that process, then it's only fair that those should go forward, and we shouldn't encourage meritless litigation to tie up projects.
Thanks. Is there anyone on the line? No?
Nope.
Okay. All right. Yeah, look, I'm strongly supportive of this. I think, probably be tweaked a little bit before, final approval. I think there's strong appetite from the entire commission on this, because we've seen this be abused, and the people that abuse it typically are, completely self-serving. The word extortion was used. I've seen that, and seldom does this result in something for the public good. Normally, this is a situation where the benefit is privatized to an attorney or to an adjacent property owner that's really just trying to extort a project from going forward for money. And we can't have that in the city. I've seen it a couple of times since I've been here, and in none of those times has it resulted in anything beneficial to the public. I've seen projects that the city very much wants to see go forward. Neighbors want to go see forward. It would improve neighborhoods, but because of somebody suing to force that development to basically pay the money to go away, and we should not be promoting that kind of behavior. So I am very supportive of this. I'll second your motion, and I think we'll tweak it along the way.
Perfect. And in the meantime, before it gets back to the commission, take a look at you're going to work with to get the changes that we need so that the city appeal would still be, would allow for a stay.
That's right.
Okay. All right, great.
You're good? Okay. Thank
And
you.
you're going to work on the second item that you can bring the rest of it. Then we'll do it in two pieces.
Yeah, did you want the second part to come as a separate ordinance to the commission in June, or did you want that to come at a later date?
It's my preference that you work on that and bring it back here, and
Okay.
that we work it here, and then once we are comfortable with it, then we send it back to we send that second piece to the commission.
So you want to continue this to the July meeting to bring back that second component?
Only continuing that second piece.
Component.
The other should
Okay.
be referred to planning with a favorable recommendation with the one change that we've discussed today. And then after planning, move the first piece to the full commission so we can hopefully get that done. And then the second one, quite frankly, if you want to bring it in July or in September, it's fine with me.
Okay.
If that's okay with the chair.
I'd like to have a little bit of urgency on this, so July's would be my preference,
Yeah,
and I think the commission would appreciate if we workshopped it here with
Yeah.
a strong recommendation one way or the other, because some of these are nuanced items, so
Right.
we'll just give it the time here and pass it to the full commission. But I think this is a matter of great importance to the city, and we should act on this as soon as we can.
I totally agree. I can't believe what has happened with the Seagull and the delay, and the delays are going to continue if we don't do something about it.
Yep.
There are others as well.
Yeah.
As we speak.
Okay, good.
Okay, good.
Tom, item 6, that's still on the agenda?
Yeah, the sponsor is okay with this moving forward because it's time sensitive. We have a memo. This was a dual referral to both the Land Use Committee and the Planning Board. The administration is supportive of this, and it basically just extends the sunset provision, which currently expires this September, and an additional 5 years to September 1, 2027. And so if the Land Use Committee is okay with this, you could endorse it and conclude it.
Okay. Mr. Larkin, do you
Nothing
want
to
to?
really say.
So the administration is supporting it?
Yes.
Are you
Just here for a
representing?
question. Here representing Urban, the co-living project that will be harmed if this sunset provision is not extended.
Well, Tom, how about this, just for the benefit of the record? What's happened since we adopted this? And, you know, we have a sunset, you said, coming in September. We're asking for, the plan sponsor is asking for a 5-year extension. What's happened since we did this overlay?
So since the overlay was developed, we have had a couple of different projects approved. There have been 2 major hotel projects that have been approved on Washington Avenue. This particular project that Mr. Larkin represents is a mixed-use project that consists of retail, restaurant, and co-living. And it also took advantage of the regulations set forth in the parking overlay for parking district number 7. However, when this parking overlay was adopted in 2015, there was a 5-year sunset provision placed in the ordinance that concludes this September. They will likely not have their building permit by this September, so they're requesting that the sunset provision be extended 5 years so that they would have an opportunity to pull their permit. The administration believes that this has been a successful tool, and we think that there could be other projects that may want to avail themselves of this, so that would be another reason to extend the sunset provision.
Yeah, it was that last part that I wanted to hear, that it's been successful to my mind and when I go down Washington Avenue. There's still a lot of work to be done, but the projects that have been completed, I think, are definitely beneficial to the neighborhood and to the district. So if we need to extend, if we need to extend it to continue the progress that's happening there, I'm supportive.
And what's the recommendation on the extension? How long?
5 years. To September 1st of 2027.
And so that's what this would do, is just to do another 5-year extension.
That's correct.
So I'll move the item.
Okay, I'll second. Okay,
Great. Thank you very much.
Okay, so we have two items left. Anybody from the public there? Okay. All right, items 15 and 16, is that all that's left?
Yeah, and Mr. Chair, on item number 16, I did speak to the item sponsor, and I told her that the administration is preparing an omnibus referral that will come to the commission for referral on June 22nd. That would include this exemption, and that we were going to request that the Land Use Committee endorse this so it could become part of that referral on June 22nd, and the sponsor was okay with that approach.
So do we need to take any action on that right now?
If you want to endorse it by acclamation, that would be great, and that would conclude the item. And then you'll see it as part of a larger referral that will be coming to the commission on June 22nd.
So does that additional piece that you're going to be doing, are you going to have to send that back to land use, or because normally if you just did that as a single, it would come to land use, right?
I think that the way that this referral is being structured, we're trying to fast track this referral to have it adopted by September. There would be time for land use to discuss it either on July 7th or on September 13th, but the plan is to have this referred to the planning board so that the planning board can consider it and transmit it on July 26th, and we can get both ordinances done at first and second reading at the September meeting, because we would like to move these fee waivers forward to incentivize workforce and affordable housing.
Yeah, and we just heard this in finance, and we're very, very supportive of it. And I think it could have an effect, a positive effect on the projects like the the Collins Park workforce housing project. So do you want us to? Your recommendation is that we move this and also allow you to do a more expansive version and send that to planning board?
Correct.
I'll move that.
Okay, great. Second. Okay.
And then just so I understand, so what's going to happen is after planning, then it's going to come to the full commission for consideration, right?
Correct. 2 readings.
Okay, perfect.
Last item is mine. It's discuss permitting live entertainment to promote arts and culture. What I wanted to discuss here is basically, what can we do throughout our city to promote arts and culture so that we don't run into conflict with what I think are overly restrictive prohibitions around live entertainment. I have spoken to our past city attorney and our current city attorney about the language in our live entertainment prohibition. I think it's overbroad and violates free speech. I won't speak for them, but they didn't dissuade me of that opinion. So at a minimum, I want to have a code that actually respects the First Amendment, but then also to think about mechanisms that we can get behind in order to promote things like arts and culture and or to support our local businesses through live entertainment. This isn't trying to open any Pandora's box to loud and raucous performances, but things like poetry readings, book readings, comedy, things that aren't even amplified whatsoever. A pantomime show would be prohibited under our current ordinance. So I want to do some cleanup work on our restrictions, but then also, have a mechanisms for business establishments, whether they're art galleries or restaurants, retail shops, to have live performances. And we can do that through restricted days like the weekends or certain hours, or they go through a modified CUP process that's not particularly expensive or onerous. And look, if they violate our noise ordinances or they violate the terms of a CUP, then they lose their right. But they should have the right to try to do things to attract business, to have a more pleasant experience for their patrons, and allow our businesses to compete with what's happening across the bay, whether it's Wynwood, the Design District, downtown Brickell, or other places. So that's why I'm bringing this up, for us to have a dialogue that we can try to do something responsible, that's respectful of folks who are afraid of this getting out of hand, but also to reflect the fact that we do have to be competitive with other parts of our community to support local businesses and to enhance the experience of our patrons. So that's where I'm at. Tom, do you want to sort of just talk about where we're at in terms of all the neighborhoods that prohibit live entertainment?
Sure. Entertainment as part of an alcoholic beverage establishment is generally permitted within any zoning district where you can have a restaurant or a bar, and that includes most non-single family districts and non-low intensity residential districts like Townhome and RM1. So in RM2 districts and in RM3 districts, as well as all commercial districts and the mixed-use entertainment districts, entertainment is permitted if the occupancy load for entertainment exceeds a certain number of people. Then approval from the planning board is required. So if the occupancy load is over 200 persons, even if it's indoors, planning board approval is required. Planning board approval is also required for outdoor entertainment, and outdoor entertainment is more restrictive in a number of these zoning districts. There are 2 areas of the city that prohibit entertainment outright, regardless of what type of entertainment it is, regardless of the volume of the music, and regardless of whether it's indoor or outdoor. And that's the area south of 5th and in the Sunset Harbor area. In both of those areas of the city, any type of entertainment is expressly prohibited.
But I think there's a, is there an exemption for hotels? Or no?
No, not that I'm aware of.
I'm just thinking in the South Fifth neighborhood, maybe they're grandfathered in, but there's the Greek restaurant down there that has live.
There may have been some restaurants, or there may have been some establishments that had an entertainment license prior to the entertainment
So they
ban
got grandfathered in?
going into effect, and so they may have been grandfathered. The same thing happened in Sunset Harbor. There were a limited number of establishments that were grandfathered.
Right. No, I'm familiar with those. I thought there was a hotel exemption. So in South of Fifth and Sunset Harbor, there's pretty much outright prohibitions of live entertainment. Collins Park, pretty much wide open. MXC, pretty much wide open.
In Collins Park, the RM2 portions of Collins Park, you're required to get conditional use approval. That's one of the few RM2 districts in the city where the planning board can consider indoor and outdoor entertainment. But MXC, outdoor entertainment requires planning board approval regardless of occupancy load, but indoor entertainment is permitted as of right if your occupancy load is under 200 persons.
Nick, do you want to walk us through what's considered live entertainment?
Sure. So our code defines entertainment very broadly to mean any live or recorded performance, whether amplified or not amplified, and basically at any volume. There's an exception for TV, radio, and recorded background music that's played at a volume that does not exceed normal conversation, which is what we define as an ambient volume level. So the issue of where performance is treated differently is that exception. Recorded background music at an ambient level is not considered entertainment, but that same music, if played live, would be at the same volume, meaning at an ambient volume level, would be considered entertainment. So it's the exception that Mr. Chairman that we've looked at, and I know you looked at with Raul and Rafael in the past.
So if I'm a restaurant owner and I plug in my iPhone to play music, as long as it's an ambient level, no problem. But if I had a DJ play that same recording live at the same volume, that's considered live entertainment.
That's right. A DJ is considered performance.
Yeah, that's what's so silly. I know that in my neighborhood in Sunset Harbor now, there's an art gallery doing an exhibition. I don't know what you would call it, live entertainment or not, but it's sort of an underwater expo. It's an experience with dinner and things like that. Nobody's complained about it, but I'm just curious whether that would be considered live entertainment.
It might be. I'm not familiar with it.
What I'm trying to do is get rid of the ludicrous stuff, right? And to try to support our local business, and not just local businesses too. As a patron, it's nice to have some vibrancy to, the restaurant dining experience or shopping experience, and I don't see why we can't do that. I mean, if it's the holidays and they want to do Christmas carols or holiday songs, that's prohibited. We have lots and lots of holidays around here. I mean, Cinco de Mayo, the Mexican restaurant in my neighborhood can't have a mariachi band. And there's endless holidays that we celebrate, and you can't do any of it. I just think it's overly restrictive, and I think there needs to be a path for businesses to apply so that they can do these things. And if they violate the terms of those permissions, then they lose the right. If they do things outside of the hours that we set forth, in which, let's say if we want to go that route, just limit it to certain hours or certain days, they lose that right. And obviously if they go beyond the volume levels that are set forth in our code, then they get fined. So that's where I'm at.
So I too find it a bit surprising that you can play your iPhone, but you can't have a DJ, and it's the same volume. So, and some of it is silliness. I think when people hear the live entertainment, the first thing they think about is they think there's going to be a nightclub that's pumping music until 5 a.m., and that's not what we're talking about. So I would be very interested in supporting some sort of trial. I think a pilot program. I think the idea of limiting maybe to certain days and weekends. I've been especially surprised. For example, in Sunset Harbor, you can't have a jazz brunch combo on Sunday afternoon. And I don't know why that would be unappealing to anyone. I think it's an amenity for the community to be able to go and enjoy that. Especially, I'm not talking about outdoor, I'm talking about indoors in a restaurant. You can't have a jazz combo, but in other parts of the city you can. So, and I don't know what your desire is today and what your goal is, but maybe we can have staff work on a draft or something. If I don't know, have you guys worked on anything?
So the commission actually a few years ago, sponsored by Commissioner Alaman, adopted an ambient entertainment pilot program in certain limited areas of the city. If the committee would like, we could bring back an ordinance looking at those, or we could bring back an ordinance looking at potentially other areas of the city that might be eligible. As I know that was very limited in its application. It's in the code. Tom, would you have anything to add to that?
No, I think that was the big thing. Is that particular ordinance was very limited in terms of the areas that it applies, and it basically only applies in those areas that currently permit entertainment. It basically provided a little bit of relief from the OC load requirements, where if somebody was over 200 persons, they may not necessarily need to go to the planning board. But if somebody is under 200 persons under that legislation, it would be easier for them just to add entertainment to their CU. But I think that particular ordinance started off as a much broader proposal to potentially allow those areas of the city that currently prohibit entertainment to have some limited type of entertainment. But the final version did not include those areas.
So what about, did the prior version include an option to say have a jazz brunch on Sunday afternoon? And restricted by date, by day of the week and hours? Was there that kind of restriction?
That one was more focused on limited geographic areas, but I don't believe it has any days or hours.
Yeah. So my feeling is I'd like to go slow with this, just because the first thing that people think of is that we're going to put music in their neighborhood and pump out noise all night, which is not the goal of what we're trying to do. So what I'd be interested in is seeing what a proposal looks like that would allow the very thing I mentioned, like sort of the Sunday afternoon brunch thing. Start with maybe between 11 a.m. and 4 p.m. or something like that, to allow people to do that on a weekend. And then, as the chair said, you've got a situation where a Mexican restaurant in Sunset Harbor can't have a mariachi band once a year. So maybe what we could do is have something where, maybe 4 times a year somebody could apply for a special permit to be able to do something on a special occasion, and, would have to come to a close by, 8 o'clock at night or something like that. I'd be interested to see what a proposal would look like. I don't know how you feel about that.
Yeah, no, look, first of all, I would be interested in piloting this. Go slow. I agree. Maybe we limit it just to restaurants. We're trying to help restaurants. Limited number of days, weekends, hours. No later than 9 p.m., 10 p.m. at the latest. Have a holiday exception where if it lands on a Tuesday and it's Cinco de Mayo or Valentine's Day, they want to have a piano player. Something like that, try to craft something that, and the smaller restaurants, try to help, our local businesses.
Yeah. So maybe
sort of low impact, to actually enhance the ambiance. The other one is, I also strongly urge our city attorney to look at just cleanup language so that we don't find ourselves in a lawsuit challenging our code and then losing and then having it blow up for the whole city. Because, I mean, I listed some things that, upon my reading would be considered live entertainment, and on their face, it's clearly an issue of free speech. And if somebody were to choose to sue us on that and win, that could open up Pandora's box.
And we're happy to look at the existing definition.
So, Chair, would you like to keep it
Why don't we bring
here?
it back? Why
Yeah,
don't we bring it
back?
What I would do also maybe, Eric, talk to Raquel or whoever you think to reach out to local businesses, see what kind of support they need from us, for us to consider. We're not talking outdoor. We're not going to do outdoor. Right. But if they had their druthers, what would they like to be able to do? And then we can consider that.
Yeah, I think certainly something that's more narrowly tailored and specific to help some businesses that already exist and are supported by our neighborhoods, I think is probably the best path to success. And I'll have those conversations, and we'll see how we can put something together.
Okay. Do we have any callers?
We have one caller, Sarah De Los Reyes.
Good morning, Sarah.
Good morning. I understand. I understand that, and as a matter of fact, the Mexican restaurant in Sunset Harbor had mariachi bands in there. We haven't said anything about it. They played for a while. It was quite loud when you were actually sitting there and eating, but we let that go. The same thing with the Bay Club. The Bay Club is allowed entertainment, and they open up the doors and they play outside. The North Tower can hear it. It's not that we do not want that. The problem is that, how about in the current entertainment environment, why don't you come up with a way that it promotes art and culture, because that is not happening in Ocean Drive. And that's live entertainment the whole time without no permit. And the neighborhood should be allowed to opt out, because we're the neighborhood that have to live with whatever happens here in the neighborhood. And as a matter of fact, the gallery, which I spoke to Rudolph, that is what he has in there is a gallery that shows how the mangroves grow, and it's like a whole activity thing inside. That's not like an entertainment or anything. It is actually culture, and it is actually looking at beautiful pictures that was done by an artist. And it's all enclosed. And number two, it's all in there. So I've been to the gallery. That's a great place to sit. You sit there. You can have. He has pipe music, which is very good. You can have a conversation inside or outside, and that is not a problem. But that doesn't happen all the time. It's something that we're going to have to control, which is something that we don't want it to do. You can try it in a place, but let the neighborhood vote on it. I don't mind a Cinco de Mayo party. I don't mind closing up the street and having like a parade once a year. We love that. But, the neighborhood should dictate that. And especially neighborhood when they have a lot of residents. I mean, we get along very well with the commercial, so that's why you have to take account on the residential, and the residential should vote on it. I mean, we might be able to vote for five activities in the neighborhood. That would be fine. That everybody would agree. That would be great. We were able to do that. Not a problem. So I think by putting an entertainment throughout the whole Miami Beach, without having to have any type of controls, it's not good, guys. It cannot be controlled. Code. We're the only ones who know what the code is. We're the only ones who know that something is playing outside. And it shouldn't be playing outside because nobody else will make the phone call. And Tom Mooney can attest to that. Thank you. Hope you take that into consideration. The residents should be able, the neighborhood should be able to vote on this. Thank you.
Thank you, Sarah. I mean, the issues with everything you said is that, you, Sarah, are the arbiter. The problem is there's laws, and the laws should be the arbiter, not just, I like this gallery and that's okay. But if it violates our code, we have to enforce our laws. The mariachi, you let it go, but they're in violation of our code. And so therein lies the problem. And I think you identify that those things really don't hurt the neighborhood, so why don't we allow those things to happen? And the Bay Club is grandfathered in, and they do have lots of live entertainment, from karaoke to comedians to acoustic night, and it's a great neighborhood amenity, and it doesn't bother anybody. So it's proof that this can work. The problem is when you do prohibition and actually enforce it, and not just what some self-appointed homeowner association president says is acceptable to her. That's where you have a system of law of man, not of of laws. And so we have to follow laws and have laws that actually work for everybody, and not just you pick and choose what somebody likes.
We have one more caller, Wayne Roberts.
Hi, Wayne.
Hey, good morning, Ricky. Where do I begin? So I kind of agree that we, entertainment by musicians or comedians or whatever is fine up to a certain hour. So I don't know in the code that you're considering, 10 p.m. or something like that on weekdays and 11 p.m. on weekends. So that, especially in residential areas, if it's in commercial areas, truly commercial areas, I don't really see a problem at all. But in residential areas, past 10 p.m. would be annoying midweek, and certainly midweek and 11 p.m. on weekends. So I don't know if there's an hour requirement within the potential code. Thank you.
Yeah, Wayne, we are talking about restricting it to certain hours. I think about where you live, Wayne, and Monty's Entertainment, Monty's Restaurant. That's an outdoor spot, and they have very often live performances there, musicians, and everybody loves it, and that's outdoors. So it can work. We trip ourselves up in these, things that might happen. And then we prohibit it from happening, rather than having something reasonable and then having mechanisms for shutting things down or curtailing them if they're not working. There's way too many examples in my own neighborhood of Sunset Harbor and South of Fifth where live entertainment coexists very nicely with residents, and everybody enjoys it. And if there's any abuse, we've got a lot of tools at our disposal to fix it. So I'm just trying to do something reasonable that we can all live with. Enhance the experience for patrons and support our local businesses, and not freak people out and disturb their peace. So, okay, so Nick, you'll work a little bit on some legal craftsmanship, and then Eric, if you want to work with Raquel to do some outreach, particularly, I guess, South of Fifth neighborhood and Sunset Harbor neighborhood, just see what kind of things they would like for us to consider. I remember a couple years back, Icebox wanted to put a piano player in there, and they were willing to work with us on restrictive hours, restrictive days, and because of this prohibition, they weren't able to do that.
Do you want us to, would it be okay to bring this back to you in September?
Sure.
Okay.
Sure.
That will give us a little bit more time. July 7th would be a tight turnaround.
Yeah.
So we'll show this as continued to September 13th.
Thank you.
Perfect.
Well, I think this meeting's adjourned. We covered everything?
Yes.
All right, thank you all for your
90
time.
minutes. I think this is the fastest one ever.